Hi guys, welcome back to my channel. Welcome if you're new. I hope you're having a wonderful day. My name is Kseniya and I make videos for people who, like myself, are going through the family-based immigration process. I'm not an immigration attorney. My videos are not legal advice. They are based purely on publicly available information, my own experience, and the experience of my subscribers. The point of my channel is to give you guys the confidence to go through this process completely on your own. In today's video, we're going to talk about the form I-751, also known as Petition to Remove Conditions on Residence. So I quickly want to mention before I begin that I have not gone through this process myself as of yet. I am personally still on a conditional green card. I have done extensive research and I have spoken with people who have gone through this process to kind of give you guys a more detailed insight on the process itself. And in the future, when I finally go through this process, I will inform you guys of my personal experience. So let's firstly talk about what is the form I-751 and what is this petition to remove conditions. Well, if you have obtained your green card through marriage and at the time of your green card issuance date, you and your petitioning spouse have not been married for more than 2 years, you will receive something known as a conditional green card. And the category listed on your green card will be CR1. Having a conditional green card means that you are a permanent resident just like any other permanent resident. However, your green card will only be valid for 2 years from the date that it was issued to you. And in order for you to become the permanent resident, meaning in order for you to receive your 10-year green card, you will need to apply for removal of this conditional status on your conditional green card. To remove these conditions, you're going to have to file Form I-751. Your status is conditional because you must prove to USCIS that you obtained a green card through a bona fide relationship, a bona fide marriage to your petitioner. So the Form I-751 allows you to provide proof, additional proof of your bona fide marriage continuing after you have received your conditional green card. So let's talk about when you must file for this Form I-751. You must file the Form I-751 before your conditional status expires. So before the 2-year mark on your conditional green card. You will be eligible to file this application as early as 90 days before the expiration date. USCIS in some cases will send you a reminder stating that your conditional residency will soon expire and you should apply for removal of conditions. However, it is still unclear why USCIS sends notices like this to some applicants and not others. Do not file I-751 earlier than that 90-day window simply because it will get rejected. USCIS actually on their site has a calculator that will give you an exact date at which you will be allowed to begin filing this I-751 application. And I will link it in the description box of this video. If you don't file your I-751 before that expiration date, you will automatically lose your permanent resident status. Life is chaotic and there's a lot of things that can happen, and in certain circumstances, USCIS will allow you to submit your I-751 application late. However, you must give them enough reason and evidence to explain why you filed this application late. The instructions of this form on page 1 do explain what you can do if you file this application late, and in what circumstances it can be forgiven. If you are still married, you must submit this application I-751 together with your spouse. So what does it mean filing it together with your spouse? So in the form instructions and in some sources online, you will see a phrase that refers to filing I-751 with your spouse. So what does it actually mean? Well, it means that the I-751 form must be signed by both you, the applicant, and also your spouse, who was your petitioner in the first place. You can file the form I-751 by yourself in certain circumstances if you are no longer married. And the people who can file this form by themselves are listed out in the form instructions on page 1 as well. It can happen in circumstances when there has been a divorce, domestic abuse situation, the death of your US citizen spouse, for instance, or perhaps there has been some other extraordinary circumstances for which you must file this application on your own. But consider, if you are filing on your own in circumstances like the death of your spouse, or if you have been a victim of domestic abuse and violence, in that case, you are not required to wait for the conditional residency expiration date, and you can file this form I-751 literally at any time. So you don't have to wait for that 90-day window. You can file it as soon as you feel like you need to file it. If you are in an unfortunate position where you have to file the form I-751 by yourself, either due to domestic abuse, divorce, or any kind of other special circumstance, I highly suggest that you contact an immigration attorney or a person who specializes in your case. The other thing I wanted to mention is, despite some information, at this time, the form I-751 cannot be filed online. You have to physically mail it to the appropriate I-751 direct filing address with all the evidence. The lockbox facilities have been changing quite frequently. You really want to check the direct filing page to see where exactly you need to mail it. Let's talk about the filing fee. So the filing fee can also be calculated using the USCIS online fee calculator. However, as of right now, the full filing fee for the Form 751 is $680. And that applies to you only if you don't have any other dependents who received their conditional green cards at the same time as you. However, if you do have derivatives, each derivative will also have to submit an $85 biometrics fee. So if you are unable to pay the fee and you really need that fee waived, you can apply for a waiver by including the application I-912 with the entire packet. Now let's talk about the most important part, and that is the evidence that you must submit with this form. And all of this evidence is also listed on page 5 of the Form I-751 instructions. And again, this evidence will only be applicable to you if you are still married and you are applying for removal of conditions with your spouse. The evidence here is going to be very similar to the evidence that you have submitted perhaps for your I-130 application. However, in this case, you want to make sure that the evidence that you are submitting is the evidence that you haven't yet sent to USCIS. So they really want to see the evidence between the time that you have actually obtained your green card and the time that you apply for removal of conditions. So that gives you almost 2 extra years of acquiring appropriate evidence with your spouse. So first of all, you want to obviously submit a copy of your conditional green card, both the front and the back of the card. Next, you want to provide proof of your relationship, so that means a copy of your marriage certificate. Next, you want to provide proof of joint financial responsibility, such as any kind of bills, joint bank accounts, insurance policies, mortgages, debts, liabilities. You also do want to provide proof of residency together, so such as a lease contract or perhaps pieces of mail or important government mail that is sent to both you and your spouse at the same address. The other good piece of evidence that you will most likely acquire is jointly filed tax returns. You can also provide copies of your driver's licenses of both you and your spouse, demonstrating that you are registered as living at the same residence. Or if you have had any kind of joint trips, you may want to provide copies of itineraries and reservations for flights and trains, any kind of joint bookings. You want to provide photos of you together over time. You may also want to obtain third-party affidavits, and I do have a video talking about third-party affidavits and how they should be written if you have screenshots from social media posts. So again, this is very similar to the I-130 application. You really want to be creative, and when USCIS reviewed your I-130 application, they may have been more lenient with the kind of evidence you were able to provide for them. This time around, they really want to see a lot more evidence. And also, you really should be including a beautifully written cover letter that can summarize all the evidence that you are submitting with your form and all the supporting documentation. I do have a sample video talking about the cover letter, which relates to mostly the I-130 petition, but I'm willing to make a cover letter for the I-751 form if you would like me to do so. One of the frequently asked questions is, am I required to change my name to my spouse's name? And the question is no, you're not required to change your name, although it is a solid piece of evidence that you can use in your case. However, changing your name is not required. Now, let's talk about the biometrics and the interview process. You may not actually have to do another biometrics appointment. In a lot of cases, and especially recently, as USCIS is trying to streamline the process for a lot of people, biometrics appointments were actually waived, and they were able to use the biometrics that they did with you when you were first applying for a green card. You will receive a notice that will either say your biometrics appointment is waived or you are invited to a new biometrics appointment. The same applies to interviews. If you are able to provide a lot of detail and a lot of really solid evidence to them, there's a high chance that your interview may be waived. If your case is very strong, there's a high chance that you won't have to show to another interview. I wanted to touch upon some recent extensions. So starting September 2021, USCIS has extended the validity of your conditional green card if you already have a pending application I-751. Once you submit your I-751 application, your current conditional green card will remain valid between 18 to 24 more months until you're able to actually receive your permanent 10-year green card. You will receive a letter of extension, and usually this statement of extension will be included with your I-797 receipt notice that you typically get after submitting a form to USCIS. This letter of extension will serve as proof of your legal status as a permanent resident in the United States. And actually, you may travel with a pending I-751 application. You will need to bring with you your conditional green card, this letter stating the validity extension, And even if your extension expires and you still haven't received your 10-year green card, you still will be able to travel. However, in that case, you will want to go to your field office for an InfoPass appointment where you will receive a stamp in your passport that will again serve as proof of your status as a permanent resident. Another thing that I wanted to mention is please make sure that you are keeping your address updated with USCIS at all times. Even if you're not planning to apply for this removal of conditions anytime soon, if you are moving at any time, literally at any time before you become a naturalized citizen, you really want to make sure that your address is always updated in the system. So you are required to notify USCIS of your address change within 10 days of moving. And you can do so by either submitting the AR11 application online. You also want to change your address on your USCIS online account, or you can submit this change of address form by mail. Finally, what I wanted to talk about is, can I apply for naturalization while my I-751 is still pending? Because it looks like right now people have been waiting for their I-751 to be approved for a very long time. And actually, in a lot of cases, you will be eligible to apply for naturalization when the time comes. So if you are a spouse of a US citizen, you will be eligible to apply for naturalization after 3 years of being a permanent resident. So in a lot of cases, what will end up happening is when you become actually eligible to apply for naturalization, you have not yet received your permanent 10-year green card, which is perfectly fine. You can go ahead and file for naturalization. So you still have to apply for removal of conditions, but you will also be able to apply for naturalization. It will probably be about 1 year after you applied for removal of conditions. And in some cases, what USCIS will do is they will hold a joint kind of interview, both for the removal of conditions application as well as your naturalization application. So I will make a video going through the form I-751 step by step. However, I just wanted to make a quick note about this form and about a part of this form that may be very confusing, and that is the language that they use in this form that can be very, very confusing for a lot of you. So when it comes to the form I-751, in this case, the petitioner is the person who is applying for removal of conditions. So you, as the immigrant, as the person who have immigrated to the United States, are now called the petitioner. This can be extremely confusing for a lot of people because on the form I-130, when you just started this entire process, the petitioner was your US citizen spouse or your permanent resident spouse who petitioned for you to come to the United States. However, now you as the immigrant are actually going to be called the petitioner. So when you are starting to look through this form and the form instructions, anytime that they are referring to a petitioner, they actually mean you, the person with the conditional green card, especially when it comes to parts that ask for biographic information and signatures. I will go over this in the I-751 form step-by-step completion guide. However, I just wanted to make that quick note in case you're wanting to jump ahead. So I hope you enjoyed this video. I hope you found this useful. Give this video a thumbs up so more people can see it. Subscribe to my channel if you haven't already, and I hope to see you in my next videos. Bye!